Good morning, everyone. Welcome to Construction Cast. Thanks for joining us once again this morning. Today, we're going to be looking at the enforcement of adjudication awards. Adjudication is something we've covered a lot on these episodes. We typically look at the process. We've looked at adjudicators and how they make their decisions and how you choose adjudicators. But we quite often get to the end and say, and then you get your decision, and that's the end. And that's the bit we're going to be looking at this morning. So what happens next, and what happens when you need to get paid and perhaps the parties aren't willing to pay you. So I've got two speakers with us this morning, and this is a rerun actually of an event we held during London International Disputes Week earlier in the year, and we thought it was a really interesting session. So we've invited our speakers back to join us again. So we've got the lovely Jennifer Jones KC from Atkin Chambers. She's typically instructed as sole counsel in multi-million-pound disputes for a range of different entities, recommended in Chambers and Partners and the Legal 500, who say of her, she's intelligent, knowledgeable, and a pleasure to work with, which has certainly been the case when we've done things together. Her main area of specialism is construction, engineering, infrastructure, professional negligence, and energy. She particularly enjoys tactical challenges inherent in managing complicated disputes and doing everything possible to obtain the best results for her clients. And then we have James Vernon, who's a partner at Beale & Co. James Boyd joined Beale & Co in 2003 and he qualified in 2005. And since then, he's gone on to become a partner in the construction and engineering group. He acts for engineers, architects, contractors, and anyone really from the construction sector in relation to a wide range of contentious matters, ranging from small fee all the way up to high value multi-party construction and engineering disputes in the UK, Ireland, and overseas. So, as I said, James, we've covered adjudication a lot in this webinar, and the discussion ends at the point where perhaps you get your decision. Before we look at enforcement and various other things, in a typical adjudication that goes how you'd expect it to, and everything happens as you might expect, what does it look like when you get that decision, and then what happens normally after an adjudication?
Yeah, morning everyone. Yeah, so you get your decision. It comes always, as we do these days, in email form from the adjudicator. Your heart skips a beat and you open the PDF and you want to read the entire decision, but ordinarily you scroll down to the end to the actual meat of what's been decided. What has been decided will be determined on how the question has been phrased in the notice of adjudication and referral. But typically speaking, if it's a money dispute, there will be a decision as to what money is due, if any, from the defending party to the claiming party. Typically, there is also a time frame for that payment, and that payment will be quite short. 7 days is typical. There may be alternatives if specific submissions have been made, or, for example, you have a situation where it's a payment that needs to be reflected in the next payment application. So rather than an immediate obligation to pay, it's an immediate obligation to assess a payment in the next cycle. So that's what you get. So your decision sets you down that, and it's what we call it's temporarily binding. The parties have to follow the decision under the Construction Act and how it works, but it's only temporarily binding. So typically that means it can be opened up in a separate court proceedings that are dealing with that issue, or that issue is encapsulated in a wider dispute. So if it's an adjudication about one variation in an account, you may then have a massive final account dispute that has many, many variations, and that's just one element. But that's what I would call a new claim. So typically it's the defending party would then start a claim that says, we don't agree with the whole account, and part of this, we've had an adjudicator's decision, but we think it's wrong, so we're opening it all up. But as the adjudicator's decision stands, that should be followed by the parties. So if it's in your favour, you should be expecting that award to be followed through. And you have the comfort that, say, for some of the topics we're going to go on to discuss, the court has determined that the adjudicator's decisions should be enforced as far as possible. Ordinarily, you don't get that far. There are pretty much two ways of going. If you're the losing party, is you pay, or you might try and discuss with the other side alternatives. you know, particularly if you've been hit with a very large one-off payment to be made, whether that's for damages for a defect or relating to a variation. You do have that to try and agree separately, because part of the temporarily binding is yes, you can have the separate court proceedings, but you could also make a separate agreement, binding agreement between the parties that deals with the adjudication, but also says, we appreciate that to wrap it all up, that let's do something slightly different. So yeah, that's really what you should expect, and what you should get typically 7 days after your decision. I think you're a lot more. Again, we'll go on to discuss this, but you're a lot more confident of that payment if, for example, you've run the adjudication all the way through and it's gone through the normal phases, and the other party hasn't raised any jurisdictional concerns or reserved their position. Now, there are some jurisdictional issues that arise purely from the decision and not the fundamental threshold of starting. And again, we'll come on to that. But that should, if that hasn't happened, then as the winning party, you should feel that you're going to be paid what you've been awarded. Just very quickly, the second part of the adjudicator decision will be the determination of who pays their fees and, if appropriate, in what proportion. Now, you can win an adjudication and still be held responsible for some or all of the adjudicator's fees, depending on how they've determined it. But above that, both parties remain jointly and severally liable for the adjudicator's fees. So you can win, and the other side has to pay 100% of the adjudicator's fees, but you may still be on the hook for that as jointly and severally liable until that payment has been discharged by the losing party. And sometimes you see, it's never as straightforward sometimes, and you do get situations where defendant is to pay 100% of the adjudicator's fees, but in the first instance, the claiming party pays it, and the defending party reimburses the claimant. So you can see sort of some nuances that you do have to pick up, because you could be sat back thinking you've won and not realize that actually your client or you have to make the first payment to the adjudicator. So that's what, as the starting point, we should get after an adjudication, and it should, because that was the whole ethos of it. A quick resolution of construction disputes, ideally payment was the initial ethos. And then the parties can move on, particularly if they've still got a project to deliver.
Fantastic. So that seems fairly straightforward. So Jennifer, in the circumstances where the other side then decides they're not going to pay, what happens next? You need to enforce the award. What do you do when you need to go to court and do so?
Yeah, so as James says, actually, usually I think it's fair to say people pay up. But the TCC, the Technology and Construction Court, has a well-established procedure that you can go through to get your payment if the other side doesn't honour the decision of the adjudicator. And I will turn to what that process is in a moment. But before I do, there are a few things that you will always think about before you issue proceedings. So one of them, as James pointed out, is, do we actually want to issue proceedings, or is there a bigger deal to be done encompassing the whole project? So that would be something you would think about. You would think about the adjudicator's fees, because again, as James mentioned, both parties are liable for them in the first instance. And if you have an unsuccessful party who has declined to pay the adjudicator's fees, you as a successful party remain liable. So what you may well decide to do is honour the award yourself, pay the adjudicator's fees, so that you can put the claim for those fees into your claim in court in due course. Two reasons to do that. First of all, you have an obligation. And secondly, which feeds into the next point I'm going to make, it makes clear that you are a reasonable party who is seeking to honour the process. The third thing that you would think about before you issue proceedings is your costs recovery at the end of those proceedings. Now, the costs of the adjudication process itself are not recoverable. Each party bears their own. but the costs of the enforcement proceedings are recoverable in accordance with the usual rule, which is that the loser pays. But normally, losers pay costs on what is known as the standard basis of assessment, which amounts to about 2/3, 70% of the recovery. There is an alternative basis of assessment, which is called indemnity costs. And if you are able to put yourself into that category, you get about 90% of your costs back. In the context of adjudication, because of the rule that the losing party should just be paying up, it is often easier than in many other disputes to get your costs on the indemnity basis and to get 90% of them. But one of the things that you would wish to do before you issue proceedings is line yourself up for that as well as you possibly can. And to do that, what you'll do before you issue proceedings is send a letter or two chasing for payment, trying to resolve it, trying to prove that you're reasonable. Assume you've done all of those things, the money isn't forthcoming, and you therefore need to go to court. There's a process that's laid out in the TCC guide and has been being used for many years now. It works well. You issue your proceedings with brief particulars of claim in the normal way. Those particulars of claim are simply claiming enforcement of the adjudicator's decision. They're not claiming any sort of resolution of the substantive dispute. And you back them up with a witness statement and an application for a few things. The main thing that you are, well, two things. First of all, you apply for summary judgment on your particulars of claim. So you are applying, therefore, for a quick hearing without any oral evidence, done on the papers and with submissions from counsel. And secondly, you apply for the form of directions that is used in adjudication enforcement proceedings. And you also mark the claim form to say it's urgent adjudication business. If you do all of those things, the set of papers, when they're issued, is put on the desk of one of the TCC judges, and they put you into the fast track to have your summary judgment application heard. They'll make provision for the other side to put in evidence in response to explain why they're not paying, and other associated necessary directions. But ultimately, unless you happen to hit August, enforcement proceedings are typically heard within 6 to 8 weeks of issue. So it's very quick. You have your hearing. Often you actually don't need a hearing. Often issuing the proceedings is enough to put a stop to it. But you have your hearing, and then you should get an order for payment shortly thereafter. So it's a bit of a delay, but in comparison to a fully contested trial, for example, not much of a delay at all. And as I say, it's a well-worn route that practitioners know how to do now, so it works pretty smoothly in my experience.
Yeah. Thanks for that. So James, what are the issues then with that process that might cause difficulties?
Well, the obvious issue is whether the defending party, whether as a actual consequence of the adjudication or as a tactic, considers that they have a realistic challenge to enforcement, or sometimes it's not even realistic, but a challenge to enforcement. And predominantly they come down to a jurisdictional challenge, whether there's been a breach of your right to natural justice in terms of how the whole procedure is played out. Fraud is a potential challenge to enforcement, although that is extraordinarily rare. And the other one, which I think Jennifer will come on to, is along the lines of a stay of execution, as if, yes, the decision says this, and yes, we should comply, but for these reasons, we shouldn't be made to comply. Whereas the jurisdiction, breach of natural justice, and if relevant, fraud looks to just strike through the decision as if it hasn't been made and never existed in terms of what needs to be dealt with after the event. So typically the way jurisdiction is described is you either have an internal jurisdictional challenge, which is all about the terms of the contract. Does it comply with the provisions of the Construction Act? Are you carrying out construction operations under a construction contract? do we get over the line to even begin an adjudication? And obviously that's more on the statutory side, because if you have a contract that, although strictly speaking wouldn't be for construction operations, but has as part of the dispute resolution procedure an express right to adjudicate, then that type of argument falls away. And then the threshold is really important. Again, there is an issue of right to adjudicate, but also has the dispute crystallized. And typically you get the general reservation of right saying, I think that I might be entitled to raise a jurisdiction in the future, or there might be specific. So something might have definitively arisen. And the obvious, easiest example is the claiming party issues their notice of adjudication, and all of a sudden it lands on the desk of the responding party, and it's a dispute they had no idea existed. So they would say there's no dispute crystallized. How can we respond in tight timetables set down by the scheme and adopted in many of the other specific procedures when we're starting from scratch, or we're so far behind? This can't be fair. The difference between internal and threshold, why they're important, is typically internal jurisdictional issues, the decision will be enforced. And that can be even if the adjudicator gets it wrong in fact or even law. The policy of enforcement is that those decisions will still be enforced. It's a hollow victory if victory can be the determinant. If a court does say, well, yes, the adjudicator did get the law wrong, but I'm bound to follow the decision, because you should be entitled to make a quick claim in reply, but you still need to make the claim, and that involves time and expense, and you'll have to settle the award in the interim. So cash is king. You'll be losing that cash if it's a financial award. But it's the threshold jurisdictional challenges that go to the crux of the decision on whether it is capable of being enforced. So as I mentioned earlier, typical ones are no dispute being crystallized, dispute that is referred. So actually what has been put down on paper may be different to the one that's actually crystallized. The example we tend to give in training is you've got an application for payment 1. It says I'm due this. The dispute arises under that, but the notice refers to the dispute being under application payment 2. And arguably that dispute may not have even crystallized or even arisen yet. One of the fundamental principles of adjudication is unless you withdraw it before a decision, you get one shot on a dispute. So a dispute, as it's defined, you can adjudicate on it once. So you can't adjudicate on it and then try, and if you don't succeed, try and wrap it up in a second adjudication, maybe worded slightly differently, a bit of nuance, maybe I'll get away with it. But typically that will be resisted. And it's interesting when you look at the case law with adjudications, how many relate to a series of adjudications between the same parties on the same project, and you get to adjudication 5 and someone goes, wow, haven't we already done that one? And then you go back through it and you try and find the substance of where that decision has been made. And so that those kind of jurisdictional challenges are in control, if you like, of the claiming party, because it's how they have worded their claim. Have they properly understood it? Have they properly raised it with the other side? Are they seeking to use the tight timetable as a method of ambush? A secondary jurisdictional is actually out of the decision itself. So what the adjudicator has done, and I'll go on to briefly mention natural justice, but predominantly the jurisdiction of an adjudicator comes from the notice of adjudication. So what is the dispute they have been asked to decide? So if your dispute is for a sum of money arising under an application for payment, and they make that determination, but they might also decide, and also from what I've seen, I think you're entitled to 4 weeks extension of time. Well, that part of the decision shouldn't be enforceable. And in those cases, if there are multiple parts, it may even be severable from the main decision. But the adjudicator can't go beyond their jurisdiction. So it's for the adjudicator to really hone in on what is in dispute, what is being raised. And part of that is why you see adjudicators circulate, once submissions have closed, their view on what the issues are to be determined. And, if there is item X, entitlements to extension of time, that's when one of the parties will go, hang on, that's not part of this dispute. Another thing that adjudicators can fall foul on is basing their decision on a document that neither party have had the opportunity to respond to. Again, using as the example that has come from case law, it was a claim for extension of time, delay, LADs. Party A based their claim on a specific program, party B on a different program, and the adjudicator reached their decision on a wholly different program. But neither party had been able to make any submissions going, well, no, that's not the relevant program because, or collectively gone, do you know what? You are correct that is a decent program to rely on, but can we actually make some submissions to what it says? So you do have to read your decision carefully to ensure that the adjudicator hasn't overstepped their bounds. There are a couple of simple ones, like adjudicators are typically asked to give reasons for a decision, and if they fail to do so, then arguably that's grounds, because you just don't know how they've reached their decision. If you've got loads of submissions as to what sum of money is due and you get a one-page decision that goes, I find you are owed, I mean, that's just totally insufficient. And just briefly before we move on, I mentioned breach of natural justice. That encapsulates the party's rights to a fair hearing and the right to be heard. The example of not dealing with a submission, so you've made a key part in your defence and the adjudicator completely ignores it in the decision, that could be a ground to natural justice. Sometimes you get the feeling of the adjudicator might be openly biased, very, very rare, but it might be a risk of apparent bias or impartiality. And you may have timetable issues. So an example of ambush or not quite thinking that this dispute would occur or it's been issued while people are on holiday. Typically, an adjudicator and the parties should be alive to those issues and ensure that the timetable is slightly tweaked from the norm to ensure that those issues are addressed. So I'm a defending party. I've received this adjudication. Claiming party is perfectly entitled to bring their adjudication. You can adjudicate anytime. But so the project director or whoever's in charge is actually away for a week. So could we have a week's extension? Now, that typically should be agreed, and it would ensure that the defending party's right to natural justice is preserved, because the right person can then address the evidence. If you say he's away for a week, can we have 4 months for the decision? That's the response. That's never going to go down well. And the last thing, just to touch on, if you do think about natural justice, the breach has to be material. It can't be, a day or two, or so and so just didn't get round to producing the response, so can we have an extra day, and that was refused. You can't say that's a breach of natural justice because you've had the timetable, you can prepare for it. So we really do have to show that it's of considerable importance to the crux of the decision, that had we had the opportunity to properly consider, we would have done differently, and we may have been able to convince the adjudicator of our arguments.
Thanks, James. Jennifer, what happens if you're worried about solvency? What happens in the situation perhaps where you think the other party's not paying because they can't pay?
Well, I think there are concerns about solvency both ways. If there is a concern that the losing party isn't paying because they can't, you're then in the realm of insolvency processes and procedures. Well, I suppose initially you're in the realm of seeing if you can do an agreement, do a deal. But if there is no deal to be done, then you are in the realm of insolvency, winding up petitions, and if necessary, taking place in any insolvency as an unsecured creditor. It's obviously not a good position to be in, and is the reason that I think any representative who is acting for a claimant will want some sort of idea of the solvency of the defendant. There is also a solvency concern the other way, which is you are a losing party in an adjudication, you can pay up. You don't really want to, because your concern is that if you do pay up in compliance with your obligation to, because the decision is temporarily binding, but then you think the adjudicator has got it wrong, and so you're going to reopen the process at a later stage, and I know we'll get onto that later in this podcast, you have a concern that the money will have been spent, disappeared to the four winds, maybe the recipient company is about to be put into administration, whatever it might be, and you're never going to get your money back. And that's a real concern for unsuccessful parties in adjudication who think the adjudicator got it wrong. Now, as we've been saying, the typical rule is you just pay up. So when you are trying to avoid payment because you're concerned about getting your money back, it is a steep hill to climb, but there is a possibility. And that possibility is that, yes, the decision can in principle be enforced, but the court has a discretion in certain circumstances to stay enforcement so that you don't have to pay. Now, I should say first things first, if the claiming party is already in liquidation, there is an automatic stay. That's a function of the way the insolvency regime works. They're not in liquidation, but you're worried that you're not getting your money back. Then you can ask the court to exercise its discretion to order a stay in certain circumstances. There are, I would say, three really. First of all, you have to satisfy the court that the paying party is in fact not likely to be good to return the money. And you do that with reference to their financial documentation available at Companies House and with reference to any other information you might have. And the paying party might respond to that by saying, well, we can't pay you back, but here's a parent company guarantee, or here's some other form of security. And that's one way they might get around it. But if you can get over that hurdle first, you then have to show two things. You have to show, first of all, that there's been a change of position in the solvency of the claimant company. Because if the reality is that you always contracted with somebody who was not in a particularly strong financial position, the court will say, well, if you'd done your due diligence when you entered into the contract, you should have known that this was not a particularly robust company, and therefore you've taken the risk of finding yourself in this position. You made a commercial decision at the start, the consequences are yours to bear. So first of all, you need to show a change in the position of the solvency of the recipient company. And then secondly, you need to show that it's not your fault. Because if, of course, the recipient company says, well, we used to be fantastically solvent and secure, and the only reason we're not is that this awful paying party hasn't paid us the £5 million we're owed, and that's had a material adverse impact on our cash flow. Obviously, if that's the reason that the recipient party is unlikely to be able to repay you, it doesn't seem terribly appealing to any judge to allow you to get the benefit of simply not paying. But if you can cross all of those hurdles, then the court does have a discretion to stay enforcement and will consider whether or not it thinks it's right and proper to do that. And it's a remedy that is not successfully used very often because the thresholds that you have to pass are quite tight, but it's very much something that's in the armory and that you look at in an appropriate case. And it is certainly something that is argued from time to time and can help when all seems lost.
Thank you. James, this morning we've obviously been talking about adjudication in the UK, but there is adjudication elsewhere in the world. How is it treated differently? I know we've not got a huge amount of time, but
no, I could just deal with it quickly. It's actually one of the really interesting points. So we have the Construction Act, England and Wales. At the same time, the Construction Act Scotland was passed, and shortly thereafter, there was one for Northern Ireland as well. So if we start with Scotland and touching on what Jennifer said, one of the additional grounds you have in Scotland, if you have an adjudicator's award against you, but you have a claimant in insolvency, The way they can deal with it there is what's called balancing accounts. So you have a genuine right to set off. You are a creditor of the insolvent company, but you've lost an adjudication against them. You may be able to use that to refuse to enforce or even get a balance of account to pay you. So that's an interesting one. That's just a slightly different way in which I think the insolvency regime works in Scotland. But typically in Scotland, the enforcement principles are the same in terms of you've got jurisdictional challenges and the breach of natural justice. The process is obviously slightly different because it's a different court system. Usually, if your claim's worth over 100,000, you're in the court of session, and it's a commercial action. And the defendant can try and resist enforcement, as I said, but the way the Scottish courts have been dealing with it, the right to stay a decision doesn't exist. It's either enforceable or it's not. So it's pretty linear. And so you follow the process. They have tried to speed it up from all reports. I confess I've not had to enforce a Scottish decision, but the reports are that there is a more streamlined approach in the court of session, but it can still take a couple of months to get before. So whereas as Jennifer said, in England and Wales, you'd look to get on in 6 to 8 weeks, maybe quicker if you shop around a court. You might understand that one of the TC courts has got better capacity than another, so you might want to issue your claim in there. But it's still, within 6 months you should get a decision, so not ideal really. We also deal with sort of some adjudication issues in Ontario, and that is a different process altogether. It's you have certain eligible disputes. You need to get over that hurdle, but taking the fact that it must have been, so we've got the decision. They call it over there, the adjudicator makes a determination, and what the claimant winning party then does is files a certified copy with the court, and then once filed, it's deemed enforceable as if it was an order of the court, and you do that 7 days after the decision. So the adjudicator makes a decision, then issues a certified copy, and then the claimant will file it at the court. And then what the defendant will have to do is apply for leave or judicial review to challenge it. So you apply for leave to challenge. If that's not sufficient, you may go for judicial review. But adjudication is quite new in Ontario, so we expect that to sort of evolve as time goes by. And then just very quickly, in Ireland, adjudication in Ireland is only for payment disputes. Now there is case law as to how far parties are able to stretch what a payment dispute is, but I think if you keep that in mind, that's what the Irish statute, the Irish Construction Act laid down, and arguably that was the original ethos of the Construction Act in England and Wales and Scotland as well, to improve cash flow. The procedure over there is slightly more stepped, but it makes sense and is easy to follow. You do a motion and affidavit, which is a bit like our claim form and witness statement. You issue, and if it's unopposed or not substantially opposed, the court will proceed to a hearing date. If it's substantially opposed, the court will ask for submissions to be made. I think it was 2016 adjudication came in Ireland. There hasn't been many cases. We understand that the Irish courts will not necessarily follow enforcement case law that exists from England and Wales and Scotland. So they will look at each case on its merits and interpret it under the adjudication procedures in Ireland. That's not to say that those cases from England and Wales and Scotland might give some guidance, but you cannot think that because a decision in England and Wales has gone one particular way that the Irish courts will follow that. So that's something to be aware of. But again, they are looking for a quick turnaround in Ireland, and they look to get it before the courts as quickly as possible and to proceed to a hearing. But again, it turns on whether it's substantially challenged or not challenged at all. and that's where it stands. But I think what we see is, because England and Wales have had adjudication for longer, we have a more developed case law. And I think because of the way the statute was originally written, we've also had broader adjudication disputes that have opened up the potential for greater jurisdictional challenges and breaches of natural justice. And the obvious example is the ambush. Do we have time to respond to an expert report that we've never seen before? Now, a pure payment dispute, you would question whether you'd even need an expert report, because surely it should just be based on the financials and the evidence provided to support what was actually done on that project. So that may be one of the reasons why, aside from it being in place longer, that you will have more enforcement over here. But I think the key takeaway internationally is, just because England and Wales have got the greater case law does not mean it's always going to be followed in other jurisdictions, and you have to ensure that you know where you actually lie, and you don't want to waste, because as Jennifer says, the costs of an adjudication enforcement hearing, if you lose that, you'll have to pay that on top of the award, and that could be quite expensive.
Thanks, Jez. And our final question this morning, and I do have to apologise, Jennifer, because you've got a very short amount of time, and I suspect that this question could probably take its own session, a complete construction cost session. But you've both mentioned this morning about the temporarily binding nature. You often hear the phrase "pay now, argue later" when you talk about adjudication. So what happens if adjudication's not the last word? You've enforced it, you've got the payment, or it's been enforced, you've made the payment. It's not the last word, and you want to take it further. What do you do next in a few short minutes?
Don't worry, I will take it quickly, because you're right. One could talk about this for a very long time, and I won't. You are still entitled to reopen the dispute once you have paid, but only once you have paid. You can reopen it either by agreement, but assuming no agreement, in court if the contract says that your dispute resolution forum is court, or in arbitration if the contract chooses arbitration. You issue your proceedings and you go to a trial broadly in the normal way. It is a complete rehearing of the issues that the adjudicator has determined. The court or arbitral tribunal are not bound by what the adjudicator did. They may or may not want to look at it, depending on the personalities of the decision makers, but they consider it afresh. The main difference is that whereas the paying party in an adjudication would normally have been the defendant in any proceedings, with all that entails, you do your defence second, the other side has to make the running and take the lead in the proceedings. Because you've already paid out, you become the claimant. And therefore, the whole thing is slightly reversed in a way that most lawyers find slightly artificial, because the natural defendant is having to put their case first, which is not how we're all used to doing it. But I mean, it's perfectly doable. It can be done. It's not done very often. Typically, most people find they can live with adjudicators' decisions. But if you want to reopen, and I've got one at the moment that we're confident is going to be reopened, it's worth enough money, then yeah, you issue proceedings and off you go through the normal process in the normal timescales. But that is what you do.
Perfect. Thank you so much, both of you, and thank you to everyone who's joined us this morning. Really interesting session, and like I say, something, because where we normally stop at the end with your adjudicator's decision, it's really interesting to take it that little bit further this morning. As always, thank you for joining us. We'll be back. I think we're taking a break over the summer, and we'll be back for the next session in September. As usual, you can find all the past episodes on the website, and you can sign up for future episodes to join us there. Then thank you so much, James and Jennifer, for joining us this morning, and we'll see you next time.
Thanks.
Thank you. Thanks.
Bye.